there are a lot of folks out there who are going to need help and may not have the resources to engage private counsel to assist them in this. And the good news is that's what the federal defender does.
All of the federal defender offices are going to sort of scramble to identify people who were sentenced in their districts who may benefit from the ZIPPO amendments. In my experience, for something like this, probably the most fruitful way is for just individual prisoners who think they may be eligible to raise their hand. Send a letter to the federal defender in the district where you were sentenced, or have a relative call the federal defender in the district where you were sentenced, and just ask them to put you on a list.
Over 1 million Americans face sentencing every year, and it will be the most important day of their lives. But we don't fully understand the system, how broken it is, and what we can do to make it better. I'm Doug Passon. I'm a 25-year criminal defense lawyer and a sentencing expert. My goal is to bring more awareness, more fairness, and more humanity to the sentencing process. So, are you ready? Then let's get set for sentencing.
Hey everybody, Doug Passon coming to you from Studio 3553 in Scottsdale, Arizona. It's a rainy, dreary Friday afternoon here in Arizona, believe it or not. It's actually in the 80s, which is awesome. And like I said, raining, which is kind of fresh and new. So I'm pretty chill. I'm feeling very insouciant today. I learned that new word. Very chill, very fly. How are you feeling? Again? It means I'm laid back.
Oh, yeah.
I just feel like I just feel like it's Friday and the weather's right and it's raining. So anywho, hi Mark Allen. We're here, well, of course, I'm here with my all-time favorite guest, Mark Allenbaugh, who's not really a guest at this point. He's just a fixture. He's like furniture and set for sentencing, but very comfortable, fluffy, high quality, durable
like
furniture.
My plant, furniture like my plant.
Yes,
my books.
Actually, yeah, this is important. If people aren't watching this on the YouTubes, we have to see that Mark Allenbaugh has a really nice, fresh, funky, fresh background for sentencingstats.com, the source for sentencing data and analysis. The reason Mark and I are convening today is because we have been getting a lot of questions, calls, inquiries about the ZIPPO. We did a podcast episode explaining the 0-point offender reduction guidelines reduction. So I'll put a link to that in the show notes if you want some more basic info. But the developments are barring some crazy unforeseen circumstance, this thing is going into effect on November 1. But the bigger development is the commission made this retroactive, which means it's going to apply to a lot of people. And so people are saying, what are we supposed to do about this? What does it mean? How do we get it? And so we really wanted to zero in on that today for the most part. But of course, since Mark always has his finger on the pulse of all things statistics related, COVID has always been a big deal for us when it comes to sentencing in the Bureau of Prisons. And sad to say, COVID is rearing its ugly head outside and inside the walls of the prison. And so we need to talk about that because a lot of people think that's way in the rear view. Not so. So let's dig in. Let's talk to me about the 0-point offender. Where are we at and what do we do?
Okay, so last week, I think it was August 24th, the commission voted to make these two new amendments retroactive. And one amendment is the 0-point offender. What that means in a nutshell is if you have 0 criminal history points and you meet a bunch of criteria, then you're eligible for, well, not eligible, then the court must lower your total offense level by 2 levels. You get a downward adjustment of an additional 2 levels. So that's the 0-point offender. And the status points, there's another amendment that was made retroactive. And the status points has to do with whether or not you committed this particular offense that you're in prison for. If you committed that while you were on some type of judicial supervision for a prior offense. And that could be like you were on probation or supervised release or some type of judicial supervision for that prior offense. Usually it's probation. You get an extra historically you got an extra 2 criminal history points as a result of that.
Yeah.
And what that had the effect of doing was bumping up your criminal history category. Not all the time, but most of the time it would increase your criminal history category, which increased your sentencing guideline range. Now what the commission has said is if you have 7 criminal history points or less, you don't get the bump. You don't get the status points bump. So let's see what that means. Just start with that here specifically. So what we see here, this is just an excerpt from the guidelines. 4A 1.1D says you add 2 points if the defendant committed the instant offense while under any criminal justice sentence, such as probation, parole, supervised release, etc.
Yeah.
So what the new amendment says is that you only add 1 point if the defendant receives 7 or more points under sections A through D and committed the instant offense while under criminal justice. So in other words, instead of that 2 points, you only get 1 point. So that could reduce your criminal history.
Okay,
category.
but just to make sure I understand this, though, you don't even get the 1 point unless you already have 7 or more criminal history points. Is that right? Is
correct?
That
you don't even get the 1 point unless you have already. So
yeah.
Yes, thank you. So if you have less than 7, excuse me, thank you for that. If you have less than 7, you don't get any, and if you have 7 or more, you only get 1.
And my guess is that's a lot of people have less than 7 because you kind of have to work to get to
yeah,
7.
well, less than 7. So let's look at what that means in practice. So this is the actual sentencing table. And so we have the criminal history categories up here at the top.
Yeah.
And underneath those, you have the criminal history points in parentheses.
Yeah.
So a 7 is the lowest you can get to be in criminal history category 4.
Yeah.
So basically, if you have criminal history category 3 or less, you no longer get those status points. And if you're above criminal history category 3, like 4, 5, or 6, you only get 1 now.
Okay.
And so let me just use an example real quick. So let's say you're in prison right now and you're in criminal history category 3 at sentencing. That's what you're at. But you had 5 criminal history points. Now that's going to get reduced by 2. So 4, 3. Now you're going to move into criminal history category 3, which has the effect of reducing your guideline range. And that would allow the court to reduce your sentence.
Okay, good. And
so
that's really good because there's 6 criminal history categories, and that means you could be in 1, 2, or 3 and still be safe. 0, you get two levels off and not get that enhancement if you're a first time. Okay.
Right. So if you're a 5, so if you're a 5 and you had 10 criminal history points, now you only have 9. Because if you got those, so it doesn't apply to everybody across the board. You have to have gotten those 2 extra points for status.
Or if you're a 4 and you have 7 criminal history points, you drop down to a 3.
Right. Yeah.
Okay. So so that's good news all around, and that's good because I don't think we talked much about status offense. We were focused solely on the 0 point offender offense level reduction, which is different than criminal history category. So good. Okay.
So now 0 point offender, which is the one that gets more attention, but it actually affects less defendants. So this one, and forgive me for this busy slide, this is actually the amended guideline language. So starting November 1, we have a new section of the guidelines, 4C 1.1, which applies to the 0 point offenders. And again, it's now been made retroactive. So if you're in prison right now and you had 0 criminal history points at sentencing, you may, and I'll talk about the eligibility limits on eligibility, but you may be eligible for a resentencing to basically reduce your sentence. So these are the new 4C 1.1. If you meet all these criteria, the 10 criteria, basically, first of all, of course, you had to have 0 criminal history points. This was not a terrorism case. There was no credible use of violence or threats or death or serious bodily injury resulted. Sex offense, which would include child pornography, that would rule you out. So unfortunately, if you had a child pornography offense, you're not going to be eligible for this. The defendant did not commit personally any substantial financial hardship. So this may rule out a small subset of white collar offenders. But that key is whether they personally caused substantial financial hardship. If you had a gun, if you possessed or received a gun, so your 922G cases, those are going to be ruled out, unfortunately. The instant offense of conviction is not a individual rights or civil rights offense. So, and there's not many of those, so that's not really anything to worry about. It wasn't a hate crime, can't have been a hate crime or serious human rights offense. So if you were convicted of obviously a hate crime or human trafficking generally, that's going to preclude you. And then we had we spent a lot of time talking about this 10th criterion. And that 10th criterion says, if you got a role enhancement while you were committing a continuing criminal enterprise, then you're not eligible. There's going to be a lot of litigation about this because the real question is on that 10th criterion, just getting a role enhancement alone, does that preclude you? The commission unofficially says yes, but I think there's strong arguments that we can go in elsewhere about why that's not the case. And I'll spare the details on that for now. But at any rate, if you meet all 10 of these criteria, then you can get your offense level is reduced by 2 levels. And so that basically is along the y-axis of the sentencing table. Status points affect the x-axis, the criminal history categories, and the 0-point offender affects the y-axis.
Okay.
So now, what does this mean in real life? Well, it can affect a lot of people. So this graphic here, I pulled this from the commission. This is their own calculation. What they have calculated that the status points amendment, making it retroactive, that there are currently an estimated 11,494 individuals or inmates that the status points could affect. They'd be eligible for a lower sentence, and with the 0-point offender adjustment, that would affect at least 7,272. I think more because of that 10th criterion. I think the commission's reading it incorrectly. But setting that aside, so we're looking at about 18,500, 600 inmates currently right now that this could lower their sentence. And what's really interesting is the commission even noted those where this could result in their immediate release. So the status points, applying the status points to those 11,000 offenders, 2,000 of them, just over 2,000 are theoretically could be released right now as a result. And of course, the 0-point offender enhancement, that would apply immediately to 1,200 defendants or inmates that they would be allowed to, they could potentially be released. Now, huge caveat on that.
Yeah, I was gonna say.
Huge caveat on that, yes. So the big caveat is the retroactive part of these amendments do not go into effect until February 1, 2024. So what does that mean? That means a judge can consider right now any motions that somebody files, but a judge cannot release anybody right now, cannot give effect to this amendment until February 1, 2024. So, there's going to be a lot of people released from federal prison on February 1st, 2024.
So when you say the judge can consider it, how would you get, well, I guess, let me just say, could we do an end run around this and file a motion for compassionate release on the grounds that they should be out right now? Why do they have to wait till February?
Right. Well,
or something like that.
Great segue, Doug. Great segue, because as we know, part of the big amendment package that is going to affect on November 1 was an expansion of compassionate release, the grounds that qualify for extraordinary or compelling circumstances.
Yeah.
And now the commission basically has a catch-all where it could potentially be anything could constitute those grounds. Now, the change in the guidelines, they do have something in there that changes in non-retroactive. Well, let me put it this way without getting too far in the weeds. Most likely just a change in the guidelines isn't going to constitute grounds for compassionate release. You're going to have something else in there too. But nonetheless, this can be a great gilding the lily, so to speak. If you have health issues, if you already spent more than 10 years in prison and you received an unusually long sentence, which is now a ground, this also can be worked in as an additional ground for compassionate release.
Yeah.
Because yes, you're
and-
right. There's no point in waiting until February 1.
Yeah, and I think for those who actually would immediately be eligible, but
Right.
for the February 1 deadline, some judges might be receptive to that under a compassionate release to say, why is this deadline in place? I think it's more for administration, just to
It
kind of
is.
everybody get their handle on this stuff. So is that really fair that you should be out now, but you have to wait 3-4 months? And like you just said, if you can couple that with other factors,
Correct.
you maybe don't wait. Maybe don't wait. File, because at least after November 1, file a compassionate release, because why not?
Right.
And then
Well,
what's the worst case that happens? You lose, and then you get out February 1, hopefully.
Yeah.
Right.
So, and you know, there is some merit to filing now to get in the front of the line, because the closer we get to February 1, the more motions are going to be pending there, and there's going to be a bottleneck, just like there was in the past when other guideline amendments
Are
were
you
made
talking about
retroactive.
filing compassionate release now, or
Yeah, filing compassionate
Okay.
release now,
All right.
but as using this as part of the grounds,
Gotcha.
as opposed to just waiting,
Right.
or filing compassionate release without this. I don't know why you would. And not
Well,
put-
and also it's, if you're going to reach out to an attorney, for example, me, just saying, but like it takes us a while to get these things together. We want to get documents. We may have to consult with people. So
Right.
you want to be ready to file on November 1. That doesn't mean you wait till November 1 to reach out and start working on it. So,
Right.
so it's
And
time.
there's
It's time to get moving on that, is what
It
you're
is time.
saying.
It's time to get moving. And one of the things, though, that I do want to point out is the commission is sending out a list of who they think are eligible for either of these amendments. They're sending out a list to every chief judge of every district. Just because you're not on that list doesn't mean you don't qualify. This is just the commission's estimate. They can get things wrong. And like I said, there are some arguments on some of the criteria where I think the commission is misinterpreting certain criteria, or misapplying it, I should say, and you would otherwise be eligible. So don't.
Do you know? Sorry, go ahead.
Well, be on the lookout. Be aware for those of you who may have clients or friends and family on the inside. They should be aware of this, that their chief judge is getting a copy of all those who are eligible. It will not be made public. It's not going to be a public document. So it'll just be something that the chief judge has. But just because you might not be on that list, if you contact your public defender or your attorney is able to find out if you're on the list or not, and you're not, still apply. If you think you're eligible, still apply. Don't use this list as the end all be all.
Will we be able to get our hands on the list as lawyers, or like how do we get?
Well, because I doubt it, because it's going to have case identifiers in it. It's going to identify a whole bunch of people and stuff like that. So and the
what do we
commission never
do?
publishes that.
How do we know, as lawyers or clients, how do we know if we're on the list? And if we're not on the list, how do we know why we're left off the list if we think we should be on it?
Well, Doug, that's a good question. Maybe I will call Glenn Schmidt at the commission and see if we can find out how people can find out if they're on the list or not. And I suspect that the chief judges are going to certainly distribute this to the public defender's office in their district, as well as the U.S. Attorney's office. And
it would be really easy for them to put on their website a little query box where you can put your name and your birth date in there and just see if you pop up. It doesn't seem like that would be so hard.
No.
But then I'd want to know also, if I'm not on the list, why does the commission think I'm not eligible for it? Because otherwise, how do you challenge? How do you know what to challenge?
Yeah.
Somebody's got to, they might say because of the nature of your offense or criterion 10, whatever it is,
right?
You'd think there'd be something, but all right. Well, I guess
so
that's another argument in favor of getting counsel back involved in this, because you're going to need to find out if you're on the list, and if not, why.
Right.
Okay.
And let's say you're on the list and you're eligible. Even the commission thinks you're eligible. That doesn't mean you automatically get it. This is a
Okay.
big thing to for your listeners to understand. What I have here, this is from the commission. What I have highlighted here is that the judge can give basically if you're eligible, that just opens up an opportunity for the judge to give you a lower sentence to an extent. It's not an open up just a whole new resentencing. It's very, very limited, and the judge only can give the downward adjustment or change, resentence you and give you a lower sentence after considering the factors set forth in 3553A. So basically all of your soft stuff, as you will, incapacitation, deterrence, rehabilitation, and of course, very importantly, unwarranted sentencing disparity. And hello, this is where I come in, and I can really help with demonstrating not only whether your original sentence may have constituted unwarranted sentencing disparity, but now more importantly, that your new adjusted sentence, your new lower sentence, would not constitute unwarranted disparity if the judge was so inclined to give you this new downward adjustment, award you the 0-point offender adjustment, or this eliminate status points.
Just from a procedural standpoint then, and you might not know the answer to, maybe no one knows the answer, but once you're on the list and the judge then has to make this determination, basically reconsidering 3553A factors and all that stuff, is there a procedure in place where each side gets to be heard? In other words, the defense lawyer can have their input on as to the 3553 factors or why they're whatever, and then the government will probably, object to it all and everything else. But is it like basically a resentencing at that point, or is it judge unilaterally, is she making these decisions just on her own? Like, how does that even work?
Well, you have to file a petition or a motion for a reduced sentence. You would have to file it under 3582. So the way it's worked in the past is the public defender would just file these automatically for sometimes just
like the crack when they fix the crack guidelines.
Exactly. So this might be, and what I'm showing you here, this is the order a judge would enter once he or she would grant such a reduced sentence.
Gotcha.
But somebody has to file this, either the inmate pro se or his or her attorney on the outside or the public defender. Somebody needs to file this. It's not, I'll put it this way, it's not self-executing.
Gotcha.
So just because you're on the list, don't think somebody is going to do this for you.
Okay.
And remember too, there's only so many humans in the public defender's office. So depending on what district you're in, this could be overwhelming to them, which was part of the reason why the commission pushed the effective date out to February 1 of next year, to give everybody time to get in place procedures and stuff like that.
Well, it sounds to me, Mark,
Yes.
that, because the guidelines are advisory,
yes,
and we're dealing with a guideline issue, that any judge could basically say, that's great, the ZIPPO's great, but no, I don't think so. I think the sentence you got was what you should have gotten, and I would have given you that sentence even if the ZIPPO was in effect, and so get lost.
That's correct. That's correct.
Does the judge get to consider post-defense rehabilitation as part of 3553?
Yes.
Because remember, the judge decided she made her decision based at the time of sentencing when all the bad facts of you and your crime were fresh on the forefront.
Right.
But you need to tell a story about how the person who she sentenced several years ago is a different person that's coming today, and maybe they'd be more amenable to giving you this reduction.
You've taken a lot of classes when you're on the inside. You don't have a significant or no disciplinary history. Those are huge factors. And if you do have a disciplinary history, I guarantee that the government will waive that in front of the judge and say that he or she shouldn't give you the ZIPPO or status points.
Yeah.
So
all right. Well, so that's good. That's good. I hope judges are liberally going to hand these out.
And as they should, as you alluded to earlier today, we're in another COVID wave.
Yeah.
And the BOP is not tracking COVID anymore. They stopped tracking and reporting COVID data back in May. So we don't know how many inmates may have COVID now. And certainly, we do know that the old vaccines no longer work. We need new vaccines. And there's no indication about whether the BOP is ready to roll out a new vaccine that's supposed to come out in October. So, all these inmates now are sitting ducks for reinfections
Yeah.
and what
And
have
of course, they don't have the supplies, the masks, and the
there's no
things that people need to
KN95s or
keep them safe.
N95 masks. Yeah, exactly.
And a lot of places are still overcrowded, which makes it a pressure cooker. And
Exactly.
a lot of places are totally understaffed, which
Yes.
means people aren't getting the attention they need from a medical standpoint. So yeah, it's a mess. And I think there's so much overlap between that's maybe sounds like a compassionate release thing, but if you're talking about 2 levels for 0-point offender, I think I'd want the judge to know that, yeah, I was in prison through the first for the COVID epidemic and how hard that time was with
Onerous conditions of confinement.
This was, yeah, I've been punished. The goals of punishment have been met tenfold because this was the hardest time anyone could ever imagine serving during a worldwide pandemic. And so the COVID, COVID is still an important factor now, and to talk about what your sentence was like.
Yeah,
So,
exactly.
so,
Exactly.
well, okay. So, and then just, I think, I don't know if you have more, but I did say practice pointer. We've been talking about all the people who've already been sentenced that might benefit from this, but we need to talk about people who are pending sentence because it's it's just the beginning of September. It's 2 months before this goes into effect. If your sentencing is set before 11/1, what should you be doing?
Well, you could still file or note these pending changes in your sentencing memoranda, and judges can take them under consideration. It's just that they are not required to give them if you qualify for it. That's the only difference over the next 2 months. But absolutely note this in your sentencing memorandum, especially if you do qualify for a 0-point offender or elimination of the status points, because you could tell the judge, look, judge, do it now or do it later. And you might as well have everything done at one sentencing, especially if it's coming up in the next 2 months.
Mm-hmm. Yeah.
So,
and if you can get your sentence continued until after 11/1, that might be an easy
that
way
would
to
be
go about
ideal.
doing it.
Yeah.
And I will say this, I'm starting, and I know you are too, are starting to see this show up in pre-sentence reports. Not that they're actually factoring it into the guideline calculation yet, but a lot of times lawyers don't read all the way to the end or like read all the fine print. And I was guilty of that the other day, but when I actually reread and you pointed out to me, it's in there. It's just maybe down in the very end where the
look at you should always look at part E or F.
Yeah.
Part E or F of the PSR. Generally the POs now, at least those that are aware of this pending change, will put in there whether or not your client may qualify for one of these amendments. And also don't forget Jason. Usually they'll put that there in part E or F too. They'll run the judicial sentencing information network thing that the commission has put together.
Okay.
So be sure to challenge that too, because that's all full of crap.
All right. Well, so that's great. And I always say, we're going to do this. We're going to make it real quick podcast, and it never, ever happens. And usually when I say that, it means it's going to be extra long, but I feel like today we actually accomplished something monumental.
Yes.
This is a bare bones thing. So I guess the action item would be if you think, this stuff will apply to you or you have questions about it, you can reach out to us. Go to the show notes, www.setforsentencing.com. We can take a look and give you our best input about whether this could apply to you and what maybe you can do about it.
Yep.
Sound good?
Very good. Very good.
All right. Well, thanks so much. Have a great weekend, and I will talk with you soon.
Okay. Thanks, Doug.
All right, everybody. This is going to be part 2 of the ZIPPO in action podcast. So the law is being made retroactive. People are going to have a lot of questions about whether it applies to them, and if so, how do they get the benefit of the ZIPPO, the 0-point offender? And so we've been talking with Mark Allenbaugh for quite some time, but I realize, I recognize that there are a lot of folks out there who are going to need help and may not have the resources to engage private counsel to assist them in this. And the good news is that's what the federal defender does. And the federal public defender is an incredible organization. I speak with authority because I was part of it for a dozen years. And they are very adept at handling the influx of cases that inevitably come down the pike when there is a significant change in the law or the guidelines. And most specifically, we saw this not too long ago with the crack amendment retroactivity, or the 2 points on the drug offender. So I needed to get an amazing federal public defender on this podcast to speak to what does this process look like. And my go-to amazing federal defender is my old friend. He's not old. He's a young, handsome man, but old meaning I haven't worked with him for 8 or so years at the federal defender, Keith Hilzendeger. How are you? Welcome to Set for Sentencing.
I'm well. It's good to be here.
I'm so glad that you did this. So Keith is really my go-to person for a lot of these issues. He's in the Phoenix office, and recognize that there are offices in every state in the union, and you may need the help of a federal defender. And if so, I wanted to get that perspective and give you some guidance on how this process is going to work. So, all right, Keith, you know that this avalanche of cases is coming down the pike. What does it look like from your perspective?
Well, once we found out that the ZIPPO amendments were going to be retroactive, it falls down to us to sort of figure out a plan for triaging our cases. And we divide them up sort of by district. Every federal defender office, which is in every judicial district except the Eastern District of Kentucky. But anyway, so all of the federal defender offices are going to sort of scramble to identify people who were sentenced in their districts who may benefit from the ZIPPO amendments. And so we have 3 sources of compiling a list of people who may be eligible. The first is, we comb through our own files and we ask CJA panelists to comb through their files to just identify people who they think may be eligible, and we put them on a list. The second way is the Sentencing Commission itself has its own list of people who it thinks may be eligible, and they distribute those lists to the chief judges of each judicial district, who in turn choose or don't choose to share the list with the federal defender. And then the third way, and in my experience for something like this, probably the most fruitful way, is for just individual prisoners who think they may be eligible to raise their hand. Send a letter to the federal defender in the district where you were sentenced, or have a relative call the federal defender in the district where you were sentenced, and just ask them to put you on a list.
What happens if you get on that list by raising your hand? Then is there a process? You got to go, what do you got to do? You got to pull the file, investigate whether you think they qualify, and then
yeah. So there's some bureaucratic stuff. Usually we end up getting some sort of broad authorization from the district court to review pre-sentence reports, which is really what this is going to entail. Looking at what the actual guideline calculation in a particular case was, seeing if the status points were assessed, which the commission estimates happens in like a third of cases, or if they qualify for the 0.2 levels off reduction. You have to go through there, because it's not everybody who has 0 points that gets the reduction. There's a bunch of disqualifying, aggravating factors that we would have to go through. And so that would entail some review of the pre-sentence report, the factual basis of any guilty plea, which typically is included in a plea agreement if there is one. If not, we have to gather a transcript of the change of plea hearing. And then what we will do is we will confer with somebody at the U.S. Attorney's Office and either stipulate that this person should get the reduction or litigate. And the distinction between stipulating and litigating is very much a district by district thing. I remember, because I was the point person in the Federal Defender's Office for the Drugs Minus 2 project, and our U.S. Attorney's Office basically stipulated that anybody who was eligible would get the reduction. And that made things much easier because we didn't have to litigate anything.
Yeah.
But on the other hand, I know, at least in other districts in the Ninth Circuit, where I primarily practice, there was a lot of contested litigation going on. And that I think was a product of the kinds of drug cases that we see in Arizona versus the kinds of drug cases that come up in the rest of the country. And I think it's safe to say that there are similar kinds of variations are going to crop up, especially with the 0-point amendment. People can get 0 criminal history points in a bunch of different ways. It's just not solely by this being your first conviction for anything ever. There are convictions that don't count for criminal history points for a variety of reasons.
Yeah.
And as long as the commission has said, as long as you don't have 0, as long as you have 0 criminal history points, then, and you don't fall into these exclusion criteria, then you're eligible for the reduction. So, someone in each district will compile a spreadsheet, keep track of the information, see how the cases are progressing, if there's litigation that needs to be involved. Because some of the exclusion categories are not completely self-defining, right?
Yeah. We've talked about that, especially criterion 10. There seems to be, and there's some Supreme Court, it's what the definition of whether and means or in terms of continuing criminal enterprise and leader organizer.
Yeah.
But I'm wondering if the commission is going to go do that analysis on their own and say, oh, you don't qualify because one of these criteria are met, and so we're not putting you on a list somewhere.
Well, so the commission will compile its own list, and I don't honestly know how thorough they are. I remember when I got the Drugs Minus 2 list, for instance, I looked at the first guy on the list that we got from the Sentencing Commission, and he wasn't even sentenced in Arizona. So there can be sort of glaring errors like that.
Yeah.
And so the list that you get from the commission is going to be under-inclusive in some ways and over-inclusive in other ways. And it's going to be up to the defender's office. I personally double-checked everybody on the commission's list, but that was not the source of, I would say, 90% of the people that I put on the Drugs Minus 2 spreadsheet. The people I put on the Drugs Minus 2 spreadsheet, by and large, came from self-identification.
Wow. Okay. Well, that's good to know.
The difficulty with this is, Drugs Minus 2 is easy because virtually everybody who was serving a prison sentence for a federal drug crime was eligible. I mean, depending on, unless you had an enormous quantity of drugs, which there were cases on my list that had enormous quantities of drugs, you qualified. It's not going to be quite as easy for people to self-identify here because, well, first of all, prisoners don't have access to their own pre-sentence reports very easily. They're not allowed to keep them in their property. Prisoners can, I understand, make arrangements with their counselors to look at the pre-sentence reports, but it's still not going to be apparent to an untrained prisoner to just say, oh, yes, I'm eligible for this, I'm eligible for that, I'm not eligible for this, I'm not eligible.
Yeah. Well, I think at bare minimum, hopefully a client might remember if they think they had 0 points. But even if they think, my advice would be, even if you think it's possible, raise your hand, reach out to your local federal defender or the criminal justice Act lawyer who, CJA lawyer that represented you, it'll take them 2 seconds to pull your pre-sentence report and give you some guidance about that. And, but
Exactly.
yeah, so raise your hand and contact. What do the people do in the Eastern District of Kentucky? They go to the Western District?
Yes,
Okay.
the Western District of Kentucky, they don't like actively represent people in the Eastern District, but they do a little bit of extra monitoring. That's the other kind of urgent thing is, as a practical matter, it's going to take the federal defender system as a whole a couple of months to sort of ramp up,
Yeah.
be ready to receive requests from individual prisoners or file requests for people that they know are eligible. And it's just an unfortunate reality that in that period of time while we're ramping up, some people will be released from prison. And the other limitation that's in the guideline that talks about retroactivity is the court can't reduce a sentence below time served. So you can't, for instance, if you're serving a term of supervised release, you can't go back and have the incarceration term reduced with the hope of then reducing the term of supervised release, or making the supervised release term expire kind of retrospectively. That's not how that works.
Yeah. Well, and I suppose that's one reason why the commission said we're not going to do this till February 1 or whatever. It's going to give everybody some time to get up to speed. But it's going to be a lot of work. I would hope that there'd be some like tiers of, okay, these are no brainers. Definitely they're entitled and we don't need to wait around to figure that out. And then these are the ones that we're going to have to fight about. But I don't know how that works.
Yeah,
Maybe.
That is how it will work. It's just that it's not something that I know right now because I don't have a list. I don't have sentence reports who's going to be obviously eligible and who's going to be less obviously eligible. In the meantime, between now and February 1st, if you're going to sentencing, it may be worthwhile to ask the judge for a variance to account for the new changes, even though they're not in effect right now. So that, and a judge is probably going to be very amenable to that, because what they don't want is to have to deal with another motion 6 months down the road.
Do it now or do it later.
Yeah, and they could just take care of it at the same time as the sentence is imposed.
Right. We've actually been able to get sentencing sometimes bumped till after November 1, because I think once you cleared that hurdle and the things in effect, you're golden in terms of getting a judge to do it at sentencing. But so we'll have to see. Well, I don't envy you in the sense that it sounds like you're going to have your work cut out for you. I hope there are going to be some support teams in place, because I think there's going to be a lot. Don't you think there's going to be a lot more of these than there were drugs -2?
Yes, there will be a lot more cases to screen, especially because we're screening for kind of two things at once, and because it's not just limited to drug crimes, it's literally anybody. The commission estimates that almost 19,000 prisoners will be eligible for some kind of reduction here, and the average reduction, they say, is about 14 or 15 months.
Wow.
Which is, when you say it that way, it starts to sound kind of small until you multiply 19,000 by 14 months, and then suddenly, I mean, that's a huge amount of savings.
Yeah.
For the Bureau of Prisons in terms of resources.
Yep. And 14 months is probably an eternity if you're actually in the Bureau of Prisons right now.
For sure.
All right. Well, that is so helpful. And I guess I feel compelled for people who aren't watching this on YouTube, because, we do YouTube and then we do the this is available on all the podcast things too. But if they're not watching on YouTube, they don't have the full flavor of your background, because I was asking, was that like a fake background that we do on Zoom? And no, this is really a real background, and it's Keith's home, and he's got all the law books on the shelves. So that tells you how into this law stuff that Keith Hilzendeger really is. So, he's the man. But I'm so grateful that you took the time to talk, and I'm really glad that, the federal defenders is going to be ready for this. They've dealt with similar stuff. There's processes in place. And if you are needing help, you just got to reach out, raise your hand, reach out to your local federal defender office. You can Google any local office and get a contact person and see if you can get the benefit of these reductions. And otherwise, I hope we talk again, because I bet I could think of many other topics that you would be extraordinarily useful to enlighten us on. So will you promise you'll come back soon?
I will come back if I can help enlighten the masses.
I appreciate it.
That's it for today, but before we go, I just wanted to take a moment and say thank you to you, the listener, for spending time with us today getting set for sentencing. Whether you're a lawyer, someone who could use the help, or maybe you're just a true crime buff who loves the inside scoop on how this whole thing works, I am so glad you're here, and I hope you keep listening. If you're interested in knowing more about what I do, mitigation videos, case consults, live teaching, on-demand educational content, books, articles, all of it, please visit www.dougpassonlaw.com. I'm Doug Passon. Until next time, hang in there. Wait a minute, that's a stupid way to sign off on a podcast about sentencing. Hang in there. What's the matter with you, man? I guess they call that gallows humor. Sorry. All right. Well, I will see you next time on Set for Sentencing. Bye-bye.